Howdy, ladies and gentlemen. My name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information that plenty of bad folks would rather you not have. For today's lecture, we're going to be giving an analysis and a breakdown of the recent and very controversial U.S. Supreme Court ruling in Trump versus Barbara, the one involving birthright citizenship. Now, for the first half of this lecture, it's probably going to irritate the more right-leaning individuals, but for the latter part of this lecture, it's more than likely going to irritate the more left-leaning group of individuals because, according to the opinion, and according to what's written in the 14th Amendment, what the writers and the legislators who were debating the 14th Amendment at the time, according to that, the U.S. Supreme Court did in fact apply the 14th Amendment correctly. You'll hear, well, it was meant to help with slavery. It was meant to reconstruct and get rid of any sort of these barriers that were harming these now freed men. Well, we've actually found the transcripts from the debates regarding the 14th Amendment, and it'll be made very clear that that was not the sole intent. The intent wasn't just regarding slaves, it was to get rid of regarding parentage and lineage in totality in order to establish citizenship by way of birth. So first, as I always like to do, we'll read over the actual amendment in question, then we'll go over the case, we'll go over the debates surrounding the 14th Amendment, and then I'm going to show you some sources that really make this entire question completely irrelevant because of conflicts and constitutional requirements that weren't met whenever the 14th Amendment was being considered. So let's go ahead and jump on over first to the U.S. Constitution, Amendment 14, Section 1. Please go read all of these sections. We've already gone through them a couple of times. We did it back in April whenever we were first reviewing this case and going over the oral arguments that were heard, and then we also went over it in the 14th Amendment and addressing the Supremacy Clause and 14th Amendment in the U.S. Constitution. So we're only going to focus on Section 1. That was the main section in question for this case. So you can see here, Amendment 14, passed by Congress June 13th, 1866, ratified July 9th, 1868, a 2-year time frame there. And that should say ratified in quotes. That's foreshadowing as to how we're going to determine this entire question is completely irrelevant. Section 1 says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. So if we're going to apply an originalist, a textualist framework, that alone is general and very encompassing, which when you take into context, well, it was immediately after Reconstruction, it was obviously to just deal with slavery. That may seem intuitive on paper, but as you'll see in the debates surrounding the ratification or the consideration of the 14th Amendment, the ambiguity and how the breadth of that amendment was intentional and was very encompassing. But before we get to the debates, I want to walk you through the case. Now, it's 194 pages, at least in this PDF format. As always, I would encourage you, go read this entirely for yourself. I read through it. The summary of the affirming opinion is that they almost solely rely on an English common law, which is non-binding at all. It's not enforceable here because they try to make the argument, or not because, they try to make the argument, the judges who affirmed and said that people born within the territory of these United States are immediately upon birth subjects, they relied almost solely on an English common law tradition that the founding generation left whenever they crossed the Great Pond. So very quickly, the caption of the case is Trump versus Barbara. certiorari before judgment to the United States District Court, or for the United States Court of Appeals for the First Circuit. There's the docket number, just in case you want to very quickly reference this. And it was decided, I'm sure as y'all are all aware, June 30th, 2026. The summary holding is a fair representation of what they were arguing. Held that children born in the United States to parents unlawfully or temporarily present are subject to the jurisdiction of the United States and are citizens at birth under the 14th Amendment Citizenship Clause. Once we read through the debates, you're going to see that that is the correct interpretation, the correct understanding of the legislators at the time that this amendment was being considered. The Citizenship Clause must be understood in light of its historical context from English common law to the widespread condemnation of the court's decision in Dred Scott versus Sandford. I think we've done a lecture on Dred Scott. I can't remember. English common law. There you have it. This entire opinion is going to be rendered moot because English common law, even though the founding generation alluded to it and used it as a draft, it is not binding here. Remember, they seceded from English common law. Common law in totality they left in Britain because common law inherently is left and decided by the whims of whoever is wearing the gown and wielding the gavel, or the magistrate. Common law, per its name, was whatever law was commonly upheld in the courts, which changed from time to time and would change just depending upon the feel of the magistrate on that day, which is why they went directly opposite of that and made a government of laws rather than of men. So no, English common law, Just Sully, is not binding here, is not applicable here. You do not get to enforce foreign laws here. Nowhere in the U.S. Constitution does it say, and by the way, we're carrying over English common law. We're carrying over all of these implied powers. No, they did the exact opposite. They said whatever is listed here are the only powers this government gets to exercise. Everything else, inclusio unius est exclusio alterius, everything else not listed is retained by the citizens of the states and by the states, by the states themselves. So already off to a horrible start. Scroll down a little bit further and you'll see it time and time again how just heavily they depended upon this foreign legal theory. This common law of citizenship known as jus soli, or right of the soil, crossed the Atlantic and prevailed in each and all of the states. No, not even a little bit. After American independence. Again, commentaries on American law. The rule was applied even to the novel situation of quasi-sovereign Indian tribes who maintained dominions of their own, such that Indians born under those dominions were not citizens, but members of alien and sovereign tribes. And like with all lies, there's a tiny nugget of truth to make it convincingly true. You'll hear all of these people say, well, the founding generation, like what Roberts is saying here, the founding generation actually did bring over across the Atlantic this idea of jus soli, that they affirmed of birthright citizenship. And if you completely exclude everything else that they said and all of the qualifications required for birthright citizenship, you would be absolutely correct. Because you're right, a number of the founding generation said, yeah, if you're born here, you're a natural born citizen. Thomas Jefferson said statements to the like. James Madison said statements to the like. Alexander Hamilton said statements to the like. However, I have an act of legislation from 1790 which shows the surrounding qualifiers for what exactly it means to be born here and then to be naturally granted citizenship as a result of you being born here. It's a total lie, and it's completely bogus to try to state that the founding generation endorsed the idea of jus soli. Because you have to realize, I'm going to go on one more tangent here and then we'll get back to the case. Jus soli was used by the king, by the magistrate, to get more subjects, to get more slaves. Jus soli, in this instance, presumes that it's a good thing to become a citizen, when its inception was solely based on so the king, regardless of the status of the parent, would immediately gain authority and power and be able to subjugate another subject, another individual. Upon birth, the I mean, an incredibly wretched way of exercising authority, certainly tyrannical, and it's completely opposite of this idea of consenting to be governed. If you are governed and imposed upon from your birth, there's no consent given. Now, if you're born, and we'll get into that qualifier with the act that proves all of the requirements that the founders had, in addition to Just Sully. But point being, no, Just Sully did not make it across the pond because it is exactly opposite to the idea of a consented to governed, a consented to governing style. In a nation of immigrants, Just Sully's broad scope took on particular importance, assuring that children of foreigners, including those here on a temporary sojourn, would be an American citizen by birth alone. Yada, yada, yada. Dred Scott decision. Yada, yada, yada. More garbage. Let's scroll down a little bit further. I think I highlighted a couple other places here where Roberts is saying, again, referring to English common law, the story of citizenship in the United States begins with the English common law. No, it doesn't. Not even close. Again, you can make the argument that Blackstone, that Koch influenced the thinking and the judicial structure of what the founding generation used whenever they were building their own judicial structure. But again, common law, implied powers, a natural requirement and a natural characteristic of common law, did not make it across the Atlantic. They left that in England, and they exchanged it for a government of laws, which changed through very rigorous, very difficult means. No, English common law did not make it across the Atlantic. It was left back in Britain, because that's a government of men, not a government of laws. Protection, and he's referencing Blackstone, which, if you haven't gone and watched the lecture we did on this case back in April, please go and do so, because just like the party in favor of Barbara, Roberts here is mutilating and completely perverting what Blackstone said. He gave a ton of qualifiers and a ton of conditions upon this birthright citizenship. And he had said the origin of this is the idea of birthright citizenship. The origin of this comes from a duty, which he's shown correctly here, a duty that a king has in general to people. That if someone is born on your land, in your territory, that as a fellow man, as fellow human, you have a duty to protect those who can't protect themselves, specifically the most innocent, the children. And that in return for this, that child is expected to have complete allegiance and loyalty to that king. Do you see how that directly contradicts the whole consent of governed concept? That you upon birth are immediately and perpetually, at least until the king says otherwise, are a subject of this government that you had no idea you were subjected to. And that was one of the requirements that Blackstone was outlining. Please go read that section, go watch that lecture. There are quite a few interesting requirements and conditions that Blackstone outlines in addition to this Just Sully idea. In all other respects, however, the sovereign's power and his claim to the people's allegiance was complete. Exactly, like a slave. A foreign mother, so wouldn't you find that ironic? They try to defame Dred Scott for dealing with property and the correct placement of the title of property, but then are hailing this idea of Just Sully, which was intended and created for the sole purpose of growing the king's influence in number of subjects, i.e. slaves. And they were his subject until he decided otherwise, because they owed allegiance to him for protecting their lives whenever they couldn't protect it themselves. How ironic. A foreign mother could enter the British Isles, give birth, and leave with her child the very next day, and that child would remain a British subject. Why? Because the child owed an implied allegiance to the sovereign who protected him at his birth, no matter how momentary and uncertain his presence in the king's realms. Please go read that section, because he says a couple other things that Roberts is just conveniently leaving out here, which makes the Blackstone position much less friendly, much less welcoming to this position. This view crossed the Atlantic with the colonists. No, it didn't. That's just a blatant lie, completely ahistorical, and was adopted with little fanfare after the Revolution as subjects of the sovereign became citizens of the states. and that's a completely different relationship. A subject to a king has nowhere near the agency to a citizen of a state. This common law of citizenship, known as jus soli, or right of the soil, prevailed in each and all of the states after American independence and continued to emphasize reciprocal allegiance and protection. Again, he is omitting so many important requirements that you're going to see in that piece of legislation from the 1790s. Let's see. Okay, here's a couple other pieces I highlighted. I should have taken note as where I highlighted, but we'll just skip around as we go. Further, he says the 14th Amendment achieved its aim. The Citizenship Clause mirrored the common law's criteria for citizenship. The clause starts like the common law with territory. A child must be, quote, born in the United States, not elsewhere, even to American parents. And the clause ends again like the common law with sovereign power. A child must be, quote, subject to the jurisdiction of the United States, unlike, say, the families of foreign ministers. A child born on American soil and subject to American law was made an American citizen. Further, he says for nearly 2 decades after the 14th Amendment's ratification, the executive branch viewed the Citizenship Clause as, quote, simply an affirmance of the common law of England and of this country. Again, of the common law of England. That was left behind. It was not carried over. You can make the argument that it was used as a draft for the judiciary actually having been constructed, but again, the idea of common law, the idea of a government of men rather than laws, was not carried over from Britain. That was part of the big pieces that was left. So that was all that I highlighted in the affirming opinion. Again, please go and read it all for yourselves. It's worth reading through, even though all of it is completely moot, because virtually all of it depends on a foreign legal theory that was not carried over into the states in the U.S. Constitution and the respective states' constitutions. Again, we're going to get into how that tiny parcel of truth does not in any way verify that lie that supposedly jus soli crossed the Atlantic. So now we're going to look at a couple tidbits of Judge Thomas's dissenting opinions, just to highlight some of the arguments that could have been significantly better. We'll scroll down a little bit, and he says here, blacks were entitled to citizenship because they were Americans. They had no other homeland, owed no allegiance to any foreign power, and were subject to no other authority. They, quote, fought and bled in the same battles, gained and gloried in the same victories, and were liable to be called upon to defend America in time of war, alongside every other citizen. To Life and Writings of Frederick Douglass. I don't know why they're alluding to this. I would much rather see law, constitutional provisions, debate transcripts, than I would political activist publications. None of it is legally binding. The Citizenship Clause thus guaranteed them the, quote, dignity and glory of American citizenship so as to ensure that they would never be treated as second class under the law. Further, he goes on to say, the court today takes the extraordinary step of holding facially unconstitutional the president's order excluding from citizenship the children of foreign temporary visitors and illegal aliens. In doing so, the court adds to the sad history of the 14th Amendment, which was designed and understood to secure equal rights for the freed blacks, but has instead been repurposed for political projects that the Reconstruction Congress did not support. That's not true. Because many potential applications of the President's order are consistent with the original public meaning of the Citizenship Clause, I respectfully dissent. He is just historically and factually incorrect here. Repurposed for the political projects that the Reconstruction Congress did not support. You're going to see very soon that that is not true at all. Further down, he says, the United States thus did not claim as a citizen every child born on its soil. Again, a parcel of truth which does not verify the lie. There was a consensus among the founding generation that yes, if you're born here, you are granted citizenship, with caveats. And that would have been the most precise way, or not caveats, conditions and qualifications. That would have been an important caveat that would have made that statement there much more effective against the idea of the 14th Amendment. A little bit further down, he starts alluding to, again, more of these theoretical, kind of hegemonic understandings of law in general law, but nothing directly and explicitly stated. in the U.S. Constitution or in any law made in pursuance of the U.S. Constitution. He says the law of domicile is essential to understanding the citizenship provisions of the Civil Rights Act and the 14th Amendment, so I briefly explain the relevant parts of the law of domicile here. Again, you don't have to go to these lengths. You don't have to appeal to these non-enumerated legal theories. These legal, even if they are long-standing legal suppositions, you don't have to go to this breadth. You don't have to go to this length. Now, the reason if you're opposing the 14th Amendment would need to go to this length is because the 14th Amendment was, in fact, intentionally vague and encompassing to include illegal aliens who were here and just gave birth and granting their children citizenship. It was intended to do that, as you're about to see with the debate surrounding the 14th Amendment. And that was the only parts that I highlighted from Judge Thomas's opinion, because the majority of the remainder of it relied on court cases and court citations and more of the political activist publications rather than actual statutory provisions and constitutional basis, constitutional backing, because the allusions he made, while maybe helpful, the historical allusions, while maybe helpful, of course, predate the 14th Amendment, which means the 14th Amendment, some argue, was put in place to override those understandings and those positions, which is a fair argument to make until you find out about the unconstitutional processing of the 14th Amendment. But before we get to that, and it's going to be my favorite part of the lecture, before we get to that, let's actually slip over to the debates in 1866 regarding and surrounding the 14th Amendment. And the first quote we have here is the one that all of the right-leaning people are leaning on and saying, huzzah, huzzah, clearly the 14th Amendment was not meant to include the children of illegal aliens. We have Mr. Howard, Jacob Howard, who was the one mainly responsible for drafting up this bill, or drafting up this amendment. And he says the First Amendment is to Section 1, declaring that, quote, all persons born in the United States and subject to the jurisdiction thereof are citizens of the United States and of the states wherein they reside. I do not propose to say anything on that subject, except that the question of citizenship has been so fully discussed in this body as not to need any further elucidation, in my opinion. This amendment, which I have offered, is simply declaratory of what I regard as the law of the land already, and that every person born within the limits of the United States and subject to their jurisdiction, notice there, not the, or its, their, plural, their jurisdiction is by virtue of natural law and national law a citizen of the United States. This will not, of course, include persons born in the United States who are foreigners, aliens, who belong to the families of ambassadors or foreign ministers accredited to the government of the United States, but will include every other class of persons. It settles the great question of citizenship and removes all doubt as to what persons are or ought not to citizens, or are not citizens of the United States. This has long been a great desideratum, good gracious, excuse me, desideratum in the jurisprudence and legislation of this country. Let's scroll a little bit further down, because that sounds great, right? That sounds like he is totally against, especially this part right here, natural law. This will not, of course, include persons born in the United States who are foreigners, aliens, who belong to the families of ambassadors or foreign ministers accredited to the government. Sounds great for the right-leaning position. But let's read a little further. Mr. Doolittle, I presume the honorable senator from Michigan does not intend by this amendment to include the Indians. I move, therefore, to amend the amendment. I presume he will have no objection to it, by inserting after the word thereof the words excluding Indians not taxed. The amendment would then read, and there's the provided change to the amendment. Mr. Howard says, I hope that amendment to the amendment will not be adopted. Indians born within the limits of the United States and who maintain their tribal relations are not, in the sense of this amendment, born subject to the jurisdiction of the United States. They are regarded, and always have been in our legislation and jurisprudence, as being quasi-foreign nations. Uh-oh. That's sounding like a not so beneficial, not so friendly statement to this previous statement that many think supports the anti-birthright citizenship position, because he's saying, and who maintain their tribal relations. So if you don't maintain your tribal relations and you are born within the limits of the United States, you could be a U.S. citizen. Well, Caleb, that's stretching that a little bit. Okay, let's read on. Mr. Cohen. Here's where it gets very clear. So Mr. Cohen opposed this on its face. Eventually, he voted in favor of the 14th Amendment. But Mr. Cohen brings up that question. What about illegal aliens? The Honorable Senator from Michigan has given this subject, I have no doubt, a good deal of his attention, and I am really desirous to have a legal definition of, quote, citizenship of the United States. What does it mean? What is its length and breadth? I would be glad if the Honorable Senator, in good earnest, would favor us with some such definition. Is the child of a Chinese immigrant in California a citizen? Is the child of a gypsy born in Pennsylvania a citizen? If so, what rights have they? Have they any more rights than a sojourner in the United States? If a traveler comes here from Ethiopia, from Australia, or from Great Britain, he is entitled to a certain extent to the protection of the laws. You cannot murder him with impunity. It is murder to kill him, the same as it is to kill another man. You cannot commit an assault and battery on him, I apprehend. He has a right to the protection of the laws, but he is not a citizen in the ordinary acceptation of the word. And it is perfectly clear that the mere fact that a man is born in the country has not heretofore entitled him to the right to exercise political power. He is not entitled by virtue of that to be an elector. An elector is one who is chosen by the people to perform that function, just the same as an officer is one chosen by the people to exercise the franchises of an office. Now, I should like to know, because really I have been puzzled for a long while and have been unable to determine exactly, either from conversation with those who ought to know, who have given this subject their attention, or from the decisions of the Supreme Court, the lines and boundaries which circumscribe that phrase, citizen of the United States. What is it? So not only are we getting confusion about that, about the extent of who exactly becomes a U.S. citizen, but now we have the author saying, well, as long as you don't owe allegiance to anybody else and you're born within the U.S., you can become a U.S. citizen, which is why Mr. Cohen is bringing up this question. What about the Chinese who are in California? What if they give birth while they're in California? Does that baby become a Californian and a U.S. citizen? So there's certainly not clarity about the 14th Amendment only applying to slaves and now freedmen, as Judge Thomas had supposed in his dissent. So far as the courts and the administration of the laws are concerned, I have supposed that every human being within their jurisdiction was in one sense of the word a citizen, that is, a person entitled to protection. But insofar as the right to hold property, particularly the right to acquire title to real estate, was concerned, that was a subject entirely within the control of the states. So if you ever doubted in those lectures where I said citizenship was left to the states to determine, there's a U.S. congressman debating the 14th Amendment saying that question has been left for the states to decide. It has been so considered in the state of Pennsylvania, and aliens and others who acknowledge no allegiance either to the state or to the general government may be limited and circumscribed in that particular. I have supposed further that it was essential to the existence of society itself, and particularly essential to the existence of a free state, that it should have the power not only of declaring who should exercise political power within its boundaries, but that if it were overrun by another and a different race, it would have the right to absolutely expel them. I do not know that there is any danger to many of the states in this union, but is it proposed that the people of California are to remain quiescent, while they are overrun by a flood of immigration of the Mongol race? Are they to be immigrated out of house and home by Chinese? I should think not. It is not supposed that the people of California in a broad and general sense have any higher rights than the people of China, but they are in possession of the country of California. And if another people of a different race, of different religion, of different manners, of different traditions, different tastes and sympathies are to come there and have the free right to locate there and settle among them, and if they have an opportunity of pouring in such an immigration as in a short time will double or treble the population of California, I ask, are the people of California powerless to protect themselves? I do not know what the contingency will ever happen, but it may be well to consider it while we are on this point. As I understand the rights of the states under the Constitution at present, California has the right, if she deems it proper, to forbid the entrance into her territory of any person she chooses who is not a citizen of some one of the United States. She cannot forbid his entrance, but unquestionably, if she was likely to be invaded by a flood of Australians or people from Borneo, man-eaters or cannibals if you please, she would have the right to say that those people should not come there. It depends upon the inherent character of the men. Why, sir, there are nations of people with whom theft is a virtue and falsehood a merit. There are people to whom polygamy is as natural as monogamy is with us. It is utterly impossible that these people can meet together and enjoy their several rights and privileges which they suppose to be natural in the same society, and it is necessary a part of the nature of things that society shall be more or less exclusive. It is utterly and totally impossible to mingle all the various families of men from the lowest form of the Hottentot up to the highest Caucasian in the same society. Sir, I trust I am as liberal as anybody toward the rights of all people, but I am unwilling on the part of my state to give up the right that she claims, and that she may exercise, and exercise before very long, of expelling a certain number of people who invade her borders. So again, if the 14th Amendment was just so clearly and universally understood to only apply to freedmen already in the United States, why is this congressman bringing up this question? Obviously, this wouldn't apply citizenship to the Chinese, and definitely not the children of Chinese people in states like California. If it was so clear that the 14th Amendment only applied to freedmen, why is this discussion being had at the time the 14th Amendment was being considered? Who owe to her no allegiance, who pretend to owe none, who recognize no authority in her government, who have a distinct independent government of their own, an imperium in imperio, who pay no taxes, who never perform military service, who do nothing in fact which becomes the citizen, and perform none of the duties which devolve upon him, but on the other hand have no homes, pretend to own no land, live nowhere, settle as trespassers wherever they go, and whose sole merit is a universal swindle, who delight in it, who boast of it, and whose adroitness in cutting is of such a transcendent character that no skill can serve to correct it or punish it. I mean the gypsies. They wander in gangs in my state. They follow no ostensible pursuit for a livelihood. They trade horses, tell fortunes, and things disappear mysteriously. Where they came from, nobody knows. Their very origin is lost in mystery. No man today can tell from whence the Zingara come or whither they go, but it is understood that they are a distinct people. They never intermingle with any other. They never intermarry with any other. I believe there is no instance on record where a Zingara woman was mated with a man of any other race, although it is true that sometimes the males of that race may mate with the females of others. But I think there is no case in history where it can be found that a woman of that race, so exclusive are they, and so strong are their sexual antipathies, has been known to mate with a man of another race. These people live in the country and are born in the country. They infest society. They impose upon the simple and weak everywhere. Are those people by a constitutional amendment to be put out of the reach of the state in which they live? I mean as a class. If the mere fact of being born in the country confers that right, then they will have it. And I think it will be mischievous. I think the honorable senator from Michigan would not admit the right that the Indians of his neighborhood would have to come in upon Michigan and settle in the midst of that society and obtain the political power of that state and wield it perhaps to his exclusion. I do not know that anybody would agree to that. So we'll scroll down, and here is Mr. Conness. He's another one of the one of the congressmen affirming the 14th Amendment. He says, and this is just his introduction, so I'm not skipping over important information. This is just his request to speak. He says, if my friend from Pennsylvania, who professes to know all about gypsies and little about Chinese, knew as much of the Chinese and their habits as he professes to do of the gypsies, and which I concede to him, for I know nothing to the contrary, he would not be alarmed in our behalf because of the operation of the proposition before the Senate, or even the proposition contained in the Civil Rights Bill, so far as it involves the Chinese and us. What does that sound like? Well, they offer so much. They're here doing jobs that we wouldn't want to do, so why are you concerned about it? That's exactly the same argument that Mr. Conness is making here in 1866 for the 14th Amendment. Further, he says the proposition before us, the 14th Amendment, I will say, Mr. President, relates simply in that respect to the children begotten of Chinese parents in California, and it is proposed to declare that they shall be citizens. We have declared that by law. Now it is proposed to incorporate the same provision in the fundamental instrument of the nation. I am in favor of doing so. I voted for the proposition to declare that the children of all parentage, whatever, born in California should be regarded and treated as citizens of the United States entitled to equal civil rights with other citizens of the United States. Scroll down a little further. He says, I wish now to address a few words to what the senator from Pennsylvania has said as to the rights that California may claim as against the incursion of objectionable population from other states and countries. The state of California at various times has passed laws restrictive of Chinese immigration. It will be remembered that the Chinese came to our state as others did from all parts of the world to gather gold in large quantities, it being found there. The interference with our own people and the mines by them was deprecated by and generally objectionable to the miners in California. The Chinese are regarded also not with favor as an addition to the population in a social point of view, not that there is any intercourse between the two classes of persons there, but they are not regarded as pleasant neighbors. Their habits are not of a character that make them at all an inviting class to have near you, and the people so generally regard them. Scroll down a little further. He says, and this is where Mr. Howard makes clear his actual intention. Mr. Conness says the state of California has undertaken at different times to pass restrictive statutes as to the Chinese. The state has imposed a tax on their right to work the mines and collected it ever since the state has been organized, a tax of $4 a month on each Chinaman. But the Chinese could afford to pay that and still work in the mines, and they have done so. Various acts have been passed imposing a poll tax or head tax, a capitation tax, upon their arrival at the port of San Francisco. But all such laws, when tested before the Supreme Court of the state of California, the Supreme Tribunal of that people, have been decided to be unconstitutional and void. So what is that saying? He's saying there that the Chinese, not dealing with murder, not dealing with robbery, not dealing with those other natural facets of mankind, not being a citizen, but just in general of mankind, that you have a right to life, liberty, and property, not guaranteed or granted by government, but given to you by God upon birth. He's saying these activities that a citizen, a California citizen, would do were denied to these Chinese, not even residents, these Chinese visitors who were in California. And because these citizen-exclusive practices were denied to these foreigners, it went to the Supreme Tribunal of California and it was ruled unconstitutional and void. Mr. Howard says a very just and constitutional decision, undoubtedly. He affirms that it was unjust and that it was unconstitutional for those Chinese foreigners in California to be deprived of the privileges of a Californian citizen. Let's scroll further down. Mr. Conness says those laws have been tested in our own courts, and when passed under the influence of public feeling, there they have been declared again and again by the Supreme Court of the state of California to be void, violative of our treaty obligations, an interference with the commerce of the nation. Now, then, I beg the honorable senator from Pennsylvania, though it may be very good capital in an electioneering campaign, to declaim against the Chinese. What does that sound like? You're just a racist. Trump is a racist. He wants to deport all the Mexicans. He wants to deport all the Muslims. That's exactly what Mr. Conness is doing here. Well, it's just because you hate the Chinese and it sounds good for you on the election campaign. That's it. That's your only motive. Declaim against the Chinese, not to give himself any trouble about the Chinese, but to confine himself entirely to the injurious effects of this provision upon the encouragement of a gypsy invasion of Pennsylvania. I had never heard myself of the invasion of Pennsylvania by gypsies. I do not know, and I do not know that the honorable senator can tell us how many gypsies the census shows to be within the state of Pennsylvania. The only invasion of Pennsylvania within my recollection was an invasion by very much worse and more disastrous to the state, and more to be feared and more feared than that of gypsies. It was an invasion of rebels, which this amendment, if I understand it aright, is intended to guard against and to prevent the recurrence of. On that occasion, I am not aware, I do not remember that the state of Pennsylvania claimed the exclusive right of expelling the invaders, but on the contrary, my recollection is that Pennsylvania called loudly for the assistance of her sister states to aid in the expulsion of those invaders, did not claim it as a state right to exclude them, did not think it was a violation of the sovereign rights of the state when the citizens of New York and New Jersey went to the field in Pennsylvania and expelled those invaders. We'll scroll down a little bit further, coming back to Mr. Doolittle, because he raises a couple of interesting points, or makes a couple of clarifications. Excuse me. So Mr. Doolittle, he makes his opening statement requesting time. He says, Mr. President, citizenship, if conferred, carries with it as a matter of course the rights, the responsibilities, the duties, the immunities, the privileges of citizens. Most of that is correct except for rights. You aren't granted civil rights. There's no such thing as a civil right. Your rights come from God, and then civil liberties, civil privileges, those are a result, grantable and retractable, by the civilization in which you live. But rights are endowed by God, not by any government. I have simply raised the question... Oh, excuse me, I skipped a line. I do not intend to address the Senate at length on this question now. I have simply raised the question. I think that it would be exceedingly unwise not to adopt this amendment and to put in the Constitution of the United States the broad language proposed. So it was intentionally equivocal, intentionally ambiguous. Our fathers certainly did not act in this way, for in the Constitution as they adopted it, they excluded the Indians who were not taxed, did not enumerate them. Indeed, as a part of the population upon which they based representation and taxation, much less did they make them citizens of the United States. And here comes Mr. Trumbull giving further clarification. He says, of course my opinion is not any better than that of any other member of the Senate, but it is very clear to me that there is nothing whatever in the suggestions of the senator from Wisconsin. The provision is that, quote, all persons born in the United States and subject to the jurisdiction thereof are citizens. That means subject to the complete jurisdiction thereof. Oh, that sounds great, right? For those who oppose birthright citizenship? Well, just wait. Now, does the senator from Wisconsin pretend to say that the Navajo Indians are subject to the complete jurisdiction of the United States? What do we mean by, quote, subject to the jurisdiction of the United States? It means not owing allegiance to anybody else. That is what it means. We make treaties with them, and therefore they are not subject to our jurisdiction. So when it says, and subject to the jurisdiction thereof, it's not saying you're a subject, it's not saying you're a citizen, an approved, recognized, formalized citizen of a state. It's as long as you don't owe allegiance to any other body, any other government, that satisfies the and subject to the jurisdiction thereof requirement. We'll scroll a little bit down. Well, Caleb, that's stretching it a little bit. You're stretching Mr. Trumbull's words there a little bit. Well, Mr. Trumbull goes on further, and he says the senator from Ohio says they ought to be, if they are there and within the jurisdiction of Colorado and subject to the laws of Colorado, they ought to be citizens. And that is all that is proposed. It cannot be said of any Indian who owes allegiance, partial allegiance if you please, to some other government that he is, quote, subject to the jurisdiction of the United States. Scroll down to Mr. Johnson, and he says the same thing. Who is a citizen of the United States is an open question. The decision of the courts and the doctrine of the commentators is that every man who is a citizen of a state becomes ipso facto a citizen of the United States, and that is completely cogent with what the founding generation had set up. Let the states determine who is and who isn't a citizen, and then by way of the state's membership with the U.S., can have the U.S. Constitution provisions applied to them by way of their citizenship with the state. Not with the U.S., because we've said it a number of times, you can't be a citizen of a union. It's not a singular political body. It's a confederation, if you will, of many singular political bodies. You can be a citizen of a state. You can't be a citizen of a union. Ipso facto, a citizen of the United States. But there is no definition as to how citizenship can exist in the United States except through the medium of a citizenship in a state. Now, all that this amendment provides is that all persons born in the United States and not subject to some foreign power, that's how they're defining that second requirement, and subject to the jurisdiction thereof, as long as you're not subject to some other foreign power. For that, no doubt, is the meeting of the committee who have brought the matter before us shall be considered as citizens of the United States. That would seem to be not only a wise, but a necessary provision. And since a child upon birth, if they're here, that means they're not subjects of that foreign government. Unless you apply subjection by blood. That if your parents are loyal or citizens of a foreign government, and you're born, you're also a subject of that government. That's what they're applying here. As long as your allegiance doesn't belong to another government, that satisfies that second requirement and subject to the jurisdiction thereof. That's what the legislators were saying. That's what the Congress, at the time the 14th Amendment was being considered, understood that second part to be. It didn't just pertain to this new class of freed men. It didn't pertain just to former slaves. It pertained to, as Mr. Conness, I think, is who said it, it pertained to all, regardless of parentage. Further, he says, if there are to be citizens of the United States entitled everywhere to the character of citizens of the United States, there should be some certain definition of what citizenship is, what has created the character of citizen as between himself and the United States, and the amendment says that citizenship may depend upon birth. And I know of no better way to give rise to citizenship than the fact of birth within the territory of the United States, born of parents who at the time were subject to the authority of the United States. I am, however, by no means prepared to say, as I think I have intimated before, that being born within the United States, independent of any new constitutional provision on the subject, creates the relation of citizen to the United States. So he's saying without the 14th Amendment, if you are born within the territories of any of the United States, without the 14th Amendment, citizenship is not granted. The amendment proposed by my friend from Wisconsin, I think, and I submit to the Senate, should be adopted. The honorable member from Illinois seems to think it unnecessary because, according to his interpretation of the amendment as it stands, it excludes those who are proposed to be excluded by the amendment of the senator from Wisconsin, and he thinks that that is done by saying that those only who are born in the United States are to become citizens thereof, who at the time of their birth are, quote, subject to the jurisdiction thereof. And he supposes and states very positively that the Indians are not subject to the jurisdictions of the United States. With due deference to my friend from Illinois, I think he is in error. They are within the territorial limits of the United States. If they were not, the provision would be altogether inapplicable to them. In one sense, therefore, they are a part of the people of the United States, and independent of the manner in which we have been dealing with them, it would seem to follow necessarily that they are subject to the jurisdiction of the United States, as is anybody else who may be born within the limits of the United States. So as long as you're born within the territory, and this was agreed upon by the man almost solely responsible for the 14th Amendment and the legislators at the time, the popular understanding was no, the 14th Amendment did not exclusively apply to freedmen, to former slaves, to slaves in general. It applied to all born within the territory of these United States, as long as they didn't owe allegiance to any other government. That satisfied that second clause, the and subject to the jurisdiction thereof. And because a child can't owe allegiance to any government upon birth, they're not subject to any other jurisdiction. Thus, they're born in the U.S., and they satisfy the and subject to the jurisdiction thereof of the United States requirement. That's the true understanding of the 14th Amendment, according to the people who were writing it and according to the people who were debating it. So no, Mr. Howard was not, whenever you take that quote out of context, he was not upholding the idea of anti-birthright citizenship. He was, in fact, in favor of granting very broad, very wide citizenship. Further down, Mr. Howard says, I concur entirely with the honorable senator from Illinois in holding that the word jurisdiction, as here employed, ought to be construed so as to imply a full and complete jurisdiction on the part of the United States, coextensive in all respects with the constitutional power of the United States, whether exercised by Congress, by the executive, or by the judicial department. That is to say, the same jurisdiction and extent and quality as applies to every citizen of the United States now. Certainly, gentlemen, cannot contend that an Indian belonging to a tribe, that's the important qualifier, belonging to a tribe, although born within the limits of a state, is subject to this full and complete jurisdiction. So if they aren't loyal to the tribe, but were born within the territory or within the boundaries of the United States, Mr. Jacob Howard would say that individual would be subject to the jurisdiction of the United States and thus granted citizenship. And I believe that's all I highlighted in the debates. And of course, I'll leave the link to this source, that way you can go and review it, just so there is zero concern about mischaracterization, misrepresentation of what was going on in the debate. Go ahead and please review it. It is 400 or so pages long, at least in this PDF format, so it will probably take you some time. But considering how controversial this topic is, it might be well worth your time. Now, we're going to get to my favorite part of this lecture, and we're going to render moot this entire topic because, according to, not just my personal opinion, not just Caleb getting up on a soapbox, according to a U.S. official, the 14th Amendment wasn't actually ratified by any of the states pursuant to Article 5 of the U.S. Constitution. And I'll leave a source to this document as well. This is the Department of State Office of the Solicitor General memorandum regarding the 16th Amendment. And you're going to see why this memorandum is important and relevant, because what he does in this memorandum is he says, well, all of these different states, when it came to the 14th Amendment, broke all of these rules in the U.S. Constitution. But it was ruled that those violations were inconsequential, and the 14th was ratified. So because that could happen, we could also go ahead and force through the 16th Amendment, even though it, as well, didn't comply with all of the requirements in the U.S. Constitution. So here it is, the Department of State Office of the Solicitor General Memorandum regarding the 16th Amendment, published February 15th, 1913. He says, so again, this is not Caleb, this is Secretary of State, Solicitor General. In the resolutions of the state legislatures on file in the department ratifying the 14th Amendment to the Constitution, there are many errors of punctuation, capitalization, and wording. Just errors. Inconsequential, I'm sure. And wording, some of the errors in wording being substantial errors, as will appear from the following list. So here it is, showing the 14th Amendment in its 5 sections, and it lists every single state legislature did not comply with Article 5 of the U.S. Constitution. Article 5, if you're unfamiliar, is the one that details the procedures, outlines the process for amending the U.S. Constitution. None of the states complied with Article 5 to the U.S. Constitution. They changed in some form or fashion the 14th Amendment whenever they sent it back to the U.S. Congress, which means, since it wasn't an agreed-to, identical, one-for-one replica of the amendment, that amendment, the 14th Amendment, was not constitutionally ratified. And you can say, well, Caleb, it was really difficult to do that back then. Baloney. They were able to do it just fine with Articles 1 through 10 in the U.S. Bill of Rights, and they were able to do it just fine with Amendment 11 and Amendment 12. So the Solicitor General says, as by announcing the ratification of the 14th Amendment, the executive branch of the government ruled that these errors were immaterial, which the executive has zero, not even an implied power to do that. To say, well, sure, these state legislatures sent back all of these changes to this amendment, but we're going to say, actually, that didn't change the substance. That didn't change the intent of the amendment. So we're just going to completely ignore the changes that the states wanted to make to this amendment, and we're going to say and declare fraudulently that this amendment was ratified pursuant to Article 5 of the U.S. Constitution, which it wasn't. Again, not according to me, according to a U.S. government official. Ruled that these errors were immaterial to the adoption of the amendment. And further, as this amendment has been repeatedly before the courts and has been by them enforced, again, that doesn't mean that they're constitutional, it just means the courts were incorrect as well. And that's, the courts themselves have admitted they get things wrong all the time. They reversed a number of their opinions, ceteris paribus, without anything changing in the law, without any amendment being changed. They just felt like, turning their hat upside down for some reason. It is clear that the procedure in ratifying that amendment constitutes on this point a precedent which may be properly followed in proclaiming the adoption of the present amendment. So because they broke the rules for the 14th Amendment and the 13th Amendment, because they broke the rules then, we can break the rules now to get the 16th Amendment through. Do you see how quickly that devolves into saying and realizing, well, what's the point of having the rules in the first place if you can set a precedent of violating those rules to get whatever you want pushed through? Do you see how quickly that becomes a problem?
precedent which may be properly followed in proclaiming the adoption of the present amendment. That is to say that the Secretary of State may disregard the errors, no, those are changes, those are amendments made to the amendment that the states wanted in, containing the certified copies of the resolutions of the legislatures acting affirmatively on the proposed amendment. None of the states, not even one, correctly follow the procedure as outlined in Article 5 of the U.S. Constitution. Therefore, this amendment, the 14th Amendment, is null, non-enforceable, because it was not constitutionally ratified. And second to that, the way the 14th Amendment was imposed was also unconstitutional. You don't get to point guns at the states who refuse to adopt the amendment and say you're going to adopt it or you're going to be slaughtered. And you definitely don't get to then go and slaughter the dissent and say, we got the amendment ratified. Neither of those modes are constitutional, and by this governing official, this U.S. government official's own admission, the 14th Amendment did not comply with Article 5 of the U.S. Constitution. So what is the correct response to this? How do you deal with, okay, well, you've told us that it was illegitimate, so where do we proceed from here? There's a number of things you can do. You can have the U.S. government nullify it. You can have the Congress go ahead and repeal the 14th Amendment, rescind the 14th Amendment, or if you want to, you can keep it on the books and just never enforce it. You can have the Congress redefine the terms in the 14th Amendment, because whatever they provide as part of any sort of provision or statute that they enact, whatever definitions they provide specific to that act has to be applied for the scope of that act. So they can also redefine the terms of the 14th Amendment. The 14th Amendment can be resent to the states since it was never actually constitutionally ratified for consideration. The president, of course, since this is an unconstitutional amendment and it was fraudulently passed off as being compliant with the U.S. Constitution, the U.S. president doesn't have to enforce it, doesn't have to obey it. The state legislatures, I would definitely allude and send you to the Kentucky and Virginia resolutions of 1798, in which they said, whenever an act violates the Constitution, the states have no obligation to obey it, no obligation to enforce it. So for the state legislatures, I've been hearing plans around here in Texas that they're going to start revoking and not printing birth certificates for certain illegal aliens, for illegal aliens in general. That's completely constitutional, even if we're going to play make-believe that the 14th Amendment was ratified constitutionally. The states are absolutely within their rights to do that. The states do not have to, even if we pretend that the 14th Amendment was ratified constitutionally, which again, it wasn't. Even if we assume that, the states would still have the authority to deny citizenship of their state. Why? Because the U.S. Constitution, Article 1, Section 8, allows the Congress to define and outline the procedures for naturalization, but not citizenship. And that's, again, not a crazy Caleb getting up on his soapbox idea. We just heard that in the 14th Amendment debates. I think it was Mr. Cohen had said, as far as I understand it, the question of citizenship was left to the states. And in fact, I think we've already beat on the dead horse here enough that the 14th Amendment was not constitutionally ratified. Let's actually get to that example from the 1790s, from the founding generation, that proves this not to just be a theory, but the basis, the consensus whenever the U.S. Constitution was being written. Here we have an act to establish a uniform rule of naturalization and to enable aliens to hold lands under certain restrictions. So here's also where we're going to get clarity on the founders believed in jus soli, that they believed in birthright citizenship. Yeah, with requirements, with attachments. Section 1, be it enacted by the Senate and House of Representatives of the United States of America and Congress assembled, that any alien other than an alien enemy, so it's crossed out, looks like that was amended, not to be included, that any alien being a free white person who shall have resided within the limits and under the jurisdiction of the United States for the term of 2 years may be admitted to become a citizen. May be, not will be, may be admitted to become a citizen thereof on application to any common law court of record in any one of the states wherein he shall have resided for the term of 1 year at least, and making proof to the satisfaction of such court that he is a person of good character in taking the oath or affirmation prescribed by law to support the Constitution of the United States, which oath or affirmation such court shall administer, and the clerk of such court shall record such application and the proceedings thereon, and thereupon such person shall be a citizen of the United States. And the children of such person so naturalized. So here it is, birthright citizenship. Yep, this is the part that they take out of context. And the children of such person so naturalized, dwelling within the United States, being under the age of 21 years at the time of such naturalization, shall also be considered as citizens of the United States. So did they believe in birthright citizenship? Yep, as long as your dad had gone through this process, resided in the U.S. for 2 years, went to a common law court, applied for good character, applied for citizenship, took an oath or affirmation to support the U.S. Constitution. So many requirements that preceded the birthright citizenship. And if your father had gone through those steps, then you, as his progeny, would inherit that citizenship. So no, it didn't apply to people who were just here on a weekend and coincidentally gave birth while in the United States. And the children of citizens of the United States that may be born beyond sea or out of the limits of the United States shall be considered as natural born citizens. And that's what really solidifies that they didn't believe in just Sully. They believed in something, or they endorsed something more akin to what's called jus sanguinis, which is jurisdiction by blood. If your parents were citizens, you upon birth would be granted citizenship. It wasn't, oh, well, you just so happen to be within the territory of the states, you're automatically a citizen, or you just happen to be within the territory of the states whenever you were born, well, you're automatically granted citizenship. No, it depended on your parents. It depended upon your lineage, which is why the 14th Amendment, as made clear in the 14th Amendment debates, was to get rid of all parentage, all regard for the status of your parents, of your lineage, in order to grant you citizenship. Now here's the part that's very important for the states determine citizenship of their state. Provided that the right of citizenship shall not descend to persons whose fathers have never been resident in the United States. So I got a little bit ahead of myself, but that's a very important clause as well. Provided also that no person heretofore prescribed by any state shall be admitted a citizen as aforesaid, except by an act of a legislature of the state in which such person was prescribed. Ultimately, the states determine who is and who isn't a citizen. And that follows cogently because you can apply this litmus test to determine what powers the U.S. government has over the states and what powers the states retain from the U.S. government. The good litmus test is you can ask yourself, okay, if the United Nations can't do it, the U.S. likely can't do it. If the United Nations came out tomorrow and said, if you're born in Germany, a member to the United Nations, you're also a citizen of the United States because you were born within UN territory, that immediately grants you citizenship of the United Nations. And whoever is a member of the United Nations can freely ingress or regress between the members. So you're also a citizen of the United States. If you ask yourself, what would happen if the United Nations did this one thing and the results would be chaotic or atrocious? More than likely, the US government can't do that very same thing. A lot of the UN government, like the UN Charter, shares a lot, has many parallels with the structure of the US government and the US Constitution. So use that as a litmus test. If it seems like it would be an atrocious exertion of power for the UN to impose upon the UN members, apply that to the US context. Would it be an atrocious imposition of power for the US government to enforce that same act on the states? It's always important to remember the states were the focus. They are supposed to be the focus of the Union. The Union was formed for their benefit, not vice versa, which is why citizenship, definitely citizenship, was left to the states to decide. And for those of you who are concerned about, well, what if California wants to permit an invasion? The remedy for that would be the other states call a convention and vote to censure out the state. Of course, that would require the Congress to do their job, but then you can also have the states do it. Call an Article 5 convention if the Congress refuses to act. Point being, the founding generation thought this out pretty thoroughly. Now, there are still quite a few provisions in the U.S. Constitution that showed that Mr. Madison was still quite naive, but there are modes, there are tactics, there are methods to deal with a state who is trying to inflate its numbers for the sake of gaining more congressional representation. That can be dealt with without having the U.S. government get involved and enlarge their powers to extents that ultimately cause questions like this. Because if you leave the U.S. government, or if you allow the U.S. government to grant citizenship and determine citizenship, then it doesn't matter who crosses into whatever state's border, because it's ultimately going to be left to the U.S. government to decide if that person's a citizen or not, which again is why the founding generation left that question to the states. So, a quick summary of the points. The 14th Amendment was correctly applied by the U.S. Supreme Court, because according to the 14th Amendment debates, it was intended to completely disregard the status of parentage entirely for anyone and everyone, and as long as you're not a subject of a foreign governing power, you satisfy that second clause, the "and subject to the jurisdiction thereof" question. Judge Thomas, despite how frequently I tend to agree with his opinions and his historical support, was wrong on this matter. To Judge Roberts and his 4 or 5 cohorts, no, Jus Soli was not endorsed by the founding generation, and you need to stop applying in a treacherous manner foreign law that was explicitly left by the people who wrote the government. You swore an oath to uphold, apply, and defend. For remedies, President, you do not have to enforce the 14th Amendment because, according to the U.S. government, it was never ratified constitutionally. At a state level, states, you never surrendered the authority to deal with this. So it's up to you to define who isn't a citizen, and what you're going to do about those who aren't citizens that feel they get to enjoy your land, your territory, your property, and the culture that your cohesive citizenry has come to create. Very short and brief. The 14th Amendment was applied correctly by the U.S. Supreme Court. The 14th Amendment is unconstitutional. States determine citizenship. Nullify the 14th Amendment because, again, it was unconstitutional and it was never, ever, ever ratified pursuant to Article 5. Excellent. So if you have any questions about this topic, if you'd like more sources, more information, I can very quickly provide that to you. I see we're already hitting the hour and 20-minute mark. I tried my best to sift down all of the sources that I found in support of these positions, in support of these arguments, and it still came out to be over an hour long. But if you would like those other sources, those other pieces of information, I can very quickly provide that to you. If you have questions about previous topics we've covered in the past, or there's a topic you'd like me to cover in a future lecture, go ahead and post those down in the comments as well, because the entire purpose of the Calhoun School of Law is to equip you with the necessary skills and information such as this to combat any sort of lawfare that will be waged against you, your loved ones, or your hard-earned property. So please, if you have any questions at all, go ahead and post them down in the comments. Excellent. So my name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information that plenty of bad folks would rather you not have. I hope you enjoyed this lecture, and if not, while you're down in the comments, go ahead and let me know how I can do better so I can best serve that purpose of helping you. I hope you'll have a wonderful day, and until I see y'all in the next lecture for the next topic, I bid you all farewell.